The most important thing happening here is not the plea itself. It is the court making absolutely sure the mother understands that family court operates under a completely different set of consequences than criminal court.
Yes, Your Honor.
All right. You've heard what your lawyer has said. Is that what you want to do today?
Yes.
If you enter a plea today in this matter, it would be in addition to the plea that you've entered in the criminal case. Do you understand that?
Yes.
I don't want to scare you or anything, but this court has different powers and different authority than the criminal court does, and this has to do with your children and DHHS and the things that you could do or be required to do regarding your child, Logan. Do you understand that?
Okay.
All right. So I'm going to read to you the allegations that are pertinent. There's a request that you admit to, so that you are aware of what's being said. So the statute under which the DHHS says that you are brought under the court's authority is the juvenile court would have jurisdiction in any proceeding concerning a minor.
Yeah, maybe because I don't know.
Under the age of 18 years of age, whose home or environment by reason of neglect, cruelty, drunkenness, criminality, depravity on the part of the parent, guardian, or other custodian is unfit place for a child to live, or neglected or refused to provide proper or necessary support, education, medical, surgical, or other care necessary for the child's health or morals, or subjected the child to a substantial risk of harm of her mental well-being, and or abandoned the child without proper custody or guardianship. And the two things that they say that you did that bring you under those court jurisdiction powers is, number one, that you are the biological mother of Adrian Stimson, date of birth 4/14 of 2008, and Logan Weber, date of birth 1/4 of 2015, and that you are currently a resident of Otsego County. And secondly, on or about February 17th of 2026, you pled guilty to third-degree arson in the Circuit Court of Otsego County, and Adrian was the minor child that was the victim in the case, as he was present in the home at the time that you committed the arson, and then you were subsequently sentenced for that offense. Do you understand the nature of the allegations being made against you?
Your Honor.
All right. You have certain rights right now as to those allegations. I want to make sure that you understand those, so let me read those to you as well. You have the right to an attorney. Mr. Delaney would continue to represent you in this matter. If you wanted any additional contact with him, we will certainly grant you that opportunity. If the court would accept your plea, you'd be giving up all of the following rights that would occur at a trial. You'd be giving up your right to be tried by a judge or a jury. You'd be giving up the right to have DHHS prove the allegations by a preponderance of the evidence. You'd be giving up the right to see, hear, and question all the witnesses against you. You'd be giving up the right to subpoena or have subpoenaed any witnesses that you wish to present, and you'd be giving up your right to testify as well. In addition to that, there are some consequences if you enter a plea. Anything that you say at a plea proceeding can be used against you in future court proceedings, such as at a disposition or at a termination of parental rights hearing in the future, if that were to occur. If you were subject to a parental rights termination hearing, your obligation to support a child will continue until the court decides otherwise. You would also have appellate review available of any errors at this time of the procedure. So you have the right to appeal in the future if you wish. Do you understand those rights that I've just given to you?
You were breaking up, so I didn't hear the first two.
All right. The first two is that you have the right. I read the petition to you. You have the right to have an attorney represent you for that process. Mr. Delaney is and will continue to represent you for that. And secondly, you have the right to have a trial by a judge or by a jury, and to have all of the rights that you would have at a trial, to see, hear, and question all the witnesses against you, to present your own witnesses and evidence and get a subpoena from the court to require your witnesses to appear and testify. And you could, if you entered a plea today, anything that you say today can be used against you in any future court hearing, such as a disposition or a termination of parental rights case. Do you understand the rights that you have?
Yes.
Do you have any questions about any of those rights?
No.
The admissions come quickly, but their impact is substantial. What stands out is how little room remains for factual dispute once the key allegations are acknowledged. The biological relationship, the conviction, the victim status of the child's presence in the home, and the sentencing outcome are all confirmed without resistance.
All right. The first allegation against you then is that you are the biological mother of both Adrian and Logan, and those are your children. Is that correct?
Correct.
And at the time that this petition was made, those were both minor children, residents of Otsego County, and you were a resident of Otsego County. Is that correct?
Correct.
The second allegation is in honor about February the 17th of this year that you pled guilty to third-degree arson in the Otsego County Circuit Court. Is that correct?
Correct.
And that at the time that you pled, Adrian was still a minor child and he was the victim of that arson crime. Is that correct?
Correct.
And Adrian was home at the time that the crime was committed. Is that correct? The crime was committed at your home?
Correct.
And you've been subsequently sentenced for that criminal offense. Is that also correct?
Correct.
All right. Mr. Vernon or Mr. Delaney, do either of you have any additional factual basis questions?
No, Your Honor, we're satisfied.
I'm satisfied the court has complied with the court rule regarding the taking of this plea.
All right. Thank you very much. Mr. Vernon, do you agree?
I do, yes.
All right. I do find that it was a voluntary and accurate plea based on her answers to my questions. I believe she satisfied the requirements of the plea taking court rule, knows what she's been charged with, and has made an intelligent and voluntary decision to make this plea after consultation with her lawyer. All right, Ms. Weber, what's going to happen next is the Department of Health and Human Services is going to put together a plan for you as to what they think disposition, that is, in criminal cases, we call it a sentence, but in this court, we call it disposition, as to what they want to have happen next for you and your kids. And you'll have an opportunity then, once that report is accomplished, to review that with your lawyer, and we'll have a hearing set within the next month or two and to review that and to put it into place. So you're going to need to have contact with your attorney, Mr. Delaney, once that comes out. And so make sure that he knows where you're at, check with him on a regular basis so that that can occur. Mr. Vernon, is there anything else that we need to do today?
No, Your Honor.
Mr. Delaney, anything else?
No, thank you.
Ms. Hansel, any comments or anything to update me on how Logan's doing? You're on mute, Ms. Hansel. You put her there. We take her off.
Okay, the court muted me. I'm sorry.
Sorry about that.
No. Logan's doing fine, Your Honor, with his father.
All right. Thank you very much.
Your Honor, just
Yes.
for the record, I do represent Jesse Kent, who is a father. His whereabouts have been unknown throughout the entirety of this case, and I had no contact.
Thank you, Mr. Brown. I appreciate the update for that. All right. We will set a dispositional hearing within the court rule time period, and I'll see everybody at that next court hearing. We'll just continue the status quo as to everything else.
Thank you, Your Honor.
Go ahead.
Thank you, Judge.
Hang on just a second.
Larry represents Jesse Kent, who is the father of Adrian Stinson, who he is part of this case.
That's right.
So
Mr. Brown, yeah, Mr. Stinson, Mr. Kent is the father of Adrian, and Adrian has aged out. I think we terminated the case as to him last time I was here, if I remember correctly. So I don't know that we need to do anything more, or you need to do anything more in this particular case. because the dad would not have any continuing rights as to Logan. He's not the biological father of Logan.
Okay, thank you, Your Honor. With that information, I will consider my representation terminated.
Thank you, Mr. Brown. Appreciate that. Thank you for bringing that to my
Thank you,
attention.
Judge.
All right, that's all for
The final
today.
discussion highlights how family court cases constantly evolve as circumstances change. The conversation surrounding Jesse Kent demonstrates that legal involvement is only valuable when a person maintains a relevant connection to the issues still before the court. Once Adrian ages out and Logan remains the only child under consideration, entire legal relationships begin to disappear from the case. That narrowing process is important because it sharpens the court's focus. The judge quickly identifies which parties continue to matter and which no longer have a role in future decisions. Efficiency becomes the priority. By the end of the hearing, the court has eliminated distractions, accepted the plea, preserved the existing placement arrangement, and positioned the case for disposition. The next hearing will focus less on history and far more on the mother's ability to prove change.